Welcome to the first episode of Conversation, a series of webinars about Israel, international relations and law, organized by thinc, the Hague Initiative for International Cooperation. My name is Anna-Rosa Schlechter and I will be your host today. Today's conversation is about the International Criminal Court and UN resolutions. And our guest is Professor Gregory Rose from Wollongong University in Sydney, Australia. Thank you for being here today. And our moderator is Mr. Andrew Tucker, Director of thinc. Dear audience, you may raise questions during the conversation and in the Q&A session following the conversation by using the Q&A function at the bottom of your screen. We will try to answer all questions. Andrew, I hand over to you.
Good morning, good afternoon, good evening, everybody, wherever you might be. Welcome to this inaugural session of Conversations. I believe we have people from over 20 countries participating in this webinar, including the United Kingdom, Netherlands, Germany, Belgium, Switzerland, Austria, France, Italy, Hungary, Finland, in Africa, Uganda, South Africa, Chile, Singapore, Malaysia, Indonesia, Australia, New Zealand. It's getting a little bit late in the evening for you down there, but well, wonderful to have you. And the United States, and forgive me if I've missed some other countries. And you're all very welcome at this inaugural conversation, a series of webinars in which over the coming months, we hope to explore issues relating to international law as it applies to the Middle East. The Hague Initiative for International Cooperation, thinc, is a think tank based in The Hague here in the Netherlands with a global network of international lawyers and other experts in disciplines such as history, social geography, and religion. It's an interdisciplinary initiative to look at the way international law operates or doesn't operate, its shortcomings and its potentials in resolving complex issues. International law is important because everyone seems to be talking about it, and international legal arguments are inevitably used by actors on all sides of complex issues and disputes. And of course, the Israel/Palestine/Arab conflict is no different, in fact, even more so perhaps than many other disputes. We often look to international law and statements are made which tend to be rather simplistic, such as all Israeli settlements are illegal, without necessarily explaining why that might be the case. So we want to look in these webinars at what actually international law is. What does it say? What does it not say? How does it work? And can we really expect, or to what extent can we expect international law to provide clear answers to complex political and historical issues, such as the Israel-Palestine conflict? We're conscious that we're living in an increasingly changing world. The world today, anno 2021, looks completely different from, let's say, 1980, when Europe started to form its current policy towards the Middle East. Very different from the 1990s, when Israel entered into the Oslo agreements with the Palestinian Liberation Organization. And of course, the end of the 1990s, the fall of the wall, the end of the Cold War. We've seen the role of the United States rapidly changing in recent years. So the international environment is different, and Israel's relationship with the world around it is also changing. We've seen, for example, last year, the Abraham Accords opening a new window of opportunity for cooperation at many levels through the Middle East, significantly changing the rules of the game potentially in the way that Israel is relating with the Arab world. Now, the United Nations was set up in 1945, as we all know, at the end of the Second World War, as a new instrument to introduce a new legal order. And it is, of course, the main institution or set of institutions in which international diplomacy is conducted. Of course, it's not the only one, but it's very much at the heart and center of international relations. It's built on several pillars. One of them is the protection of individuals and peoples, humanitarian law, laws of war, and later human rights law. It's also based on principles concerning cooperation, friendly relations between nations, and development. The International Court of Justice, based in The Hague, is the primary legal judicial instrument, tribunal for the United Nations. It resolves disputes between states who consent to its jurisdiction, and it gives advisory opinions when asked by UN institutions. But since then, we've seen the explosion of international human rights law since the 1970s, and more recently, international criminal law, which we're going to talk a little bit more about today. This is a recent development. International criminal law did not exist in this way, certainly not before 1945, and not in this way before the last 20 years or so. The International Criminal Court was established, came into effect in 2002. It is the first and only truly universal international criminal court established to end impunity for the worst atrocities, war crimes, crimes against humanity. This trend started with the Nuremberg trials after the Second World War, and we saw in the 1990s specialist tribunals for the former Yugoslavia, Rwanda, for example, and then about 20 years ago, the International Criminal Court, which is a controversial institution in many respects. It's based on the principle of complementarity. And there are issues which we will explore in this webinar about the way that international criminal law interfaces with the United Nations. Let me just speak very briefly about the situation in Palestine before I introduce Professor Gregory Rose. The situation in Palestine, as it's known, was referred to the ICC, the International Criminal Court, when Palestine acceded to the court in 2015, early 2015. The background, of course, as we know, the PLO was accepted on the world stage in the 1970s as the sole legitimate representative of the Palestinian people. In the 1990s, Israel entered into Oslo Accords, a set of agreements with the PLO to try and reach a final resolution of their conflict. Those agreements are still in force. In 2012, November 29, Palestine was granted UN non-member observer state status in the UN. A controversial resolution did not amount to recognizing Palestine as a state, but opened the door for Palestine to accede to international treaties. One of those being the the Statute of Rome, the statute, that treaty that established the ICC. And Palestine became a state party to the ICC in 2015 and immediately referred the situation in Palestine to the court. The prosecutor opened an examination. 2019, she announced she believes war crimes have been committed in what is known as Palestine. And she asked the pretrial chamber for a ruling on whether the court, in fact, has jurisdiction over the territory of Palestine. And in February this year, early February, the court issued a ruling, 2 of the 3 judges, saying that the court has jurisdiction over war crimes in the territory of the West Bank, the Gaza Strip, and the Golan Heights. And a very important dissenting opinion by Judge Kovac, who was very critical of the majority. So we have the scene set now for the ICC to investigate war crimes by Palestinian and Israeli leaders in this territory. And the court relied heavily on the resolution of November 2012, 6719, to really justify the court having jurisdiction. And so this raises the question about the status of UN resolutions generally. And that's why we're delighted to have Professor Gregory Rose to talk with us about UN resolutions. What are they? When are they binding? Are they ever binding? How should we look at them under international law? So I'm delighted to introduce Gregory. He's Professor of Law at the University of Wollongong in New South Wales. He's Chair of the Academic Senate at the university. He's a former diplomat and legal advisor to the Department of Foreign Affairs and Trade in Australia. And he's also a specialist in international environmental law, law of the sea, maritime security and counter-terrorism. Very well placed to share his experience and expertise with us today. Greg, you're very welcome. Thank you so much for joining us from down under.
Thank you, Andrew. It's a delight to be able to join you this evening.
Great. Well, Greg, we've got a whole bunch of issues that we really want to get into today. And we have limited time, so we're going to do the best that we can. Could you just share with us a little bit about what are UN resolutions? How does this work? What are the prime institutions within the UN that make resolutions? And are they binding? Are they sources of international law?
Well, thanks, Andrew, for that question, which is a general introductory one into the topic of UN resolutions. And perhaps when we talk of UN resolutions, we think of them as a single thing, a unitary concept. But in fact, there are many different kinds of resolutions with different status, depending on the body that makes them. And in fact, under the UN Charter, you have the 5 organs where the 2 principal ones making resolutions are the General Assembly and the Security Council, at least those that are relevant to peace and security issues, which are our topic this evening, my time. But there are also specialized agencies outside of the UN. They also adopt resolutions, and their resolutions may or may not be binding depending upon the terms of the constitution that the organization is constituted under. So in the case of the General Assembly and the Security Council, they're constituted under the UN Charter, and the General Assembly has its powers prescribed and circumscribed in Chapter 4, and the Security Council in Chapters 6 and 7. So for General Assembly resolutions, they are specified as recommendations in Chapter 4. And the Security Council can make 2 kinds of decisions. It can make recommendations under Chapter 6 or decisions under Chapter 7. And the language used in each of those 2 chapters is distinct, in that Chapter 6 refers specifically to recommendations and Chapter 7 to decisions relating to an international peace and security situation under Article 39. So UN Security Council resolutions, about half of them are Chapter 6 and half of them are Chapter 7, and the usual pattern for adopting a resolution under Chapter 7 is to specify, so as to make it apparent what the status of the decision is. So
what about, let's start with UN General Assembly resolutions then. How are they made? And you say they're all recommendations. And we're going to talk a little bit later about how, for example, the ICC or other judicial institutions look to the UN, even the General Assembly, as being a kind of source of law. Does the General Assembly make law? Are the resolutions that they adopt binding, or are they in some way authoritative?
Well, I guess I should have been more specific, because the deeper we drill down into the details, the more distinctions there are. So in General Assembly decisions, you can have binding decisions relating to procedure. That is to say, budgets and processes, administration of the UN Secretariat. Those sorts of internal procedural matters are decided by a simple majority. That's 50+1 out of 100 type of voting majority, a simple majority. Whereas the recommendations are adopted based on again a majority of, but in this case of 2/3, and parties to the UN, or rather members of the United Nations, can vote for or against or abstain, and sometimes members choose to absent themselves from the voting chamber if that's considered more politically discreet and prudent.
So resolutions are, they're always prepared, aren't they, within committees or other bodies, and then they have to be sponsored and then brought to the table. They don't just appear out of nowhere, do they?
No, so there are 6 committees constituted under the General Assembly relating to different functions, including the legal committee, the budget committee, and such like.
Yeah.
And so they will prepare various topics for adoption by the Assembly more broadly.
Okay. And then they're voted on by states. Can you say something a little bit about the blocks of states? Because my understanding is states, normally vote in accordance with either with their geographical group that they're part of, or maybe groups such as the Organization of Islamic Cooperation, which is also a UN observer body, or some other affiliation such as the non-aligned nations. Does that affect the voting behavior of states?
Certainly, critically. So I suppose we need to keep in mind that when the United Nations were formed in 1945 and initially began, there were, I think it was 46 members as compared to 193, I think it is today. And through the process of decolonization after World War II, more and more European colonies became independent members of the United Nations. And by the mid-1960s, blocks started to form, and these were actually formalized into geopolitical blocks in I think 1968, and there are 5 blocks. So there's Western Europe, or the Western Europe and Others group, the others being Japan, Australia, New Zealand, Canada, US. So Europe plus other, what we think of as Western countries, and Japan is also part of the Asia bloc. There are some overlaps where a country may be party to more than one bloc. There's the Africa bloc with, I think, 55 members of the African continent, the Latin American and Caribbean bloc, the Western Europe bloc, and the Asia bloc, where Asia is a sort of ridiculously large bloc that stretches from West Asia, from Beirut through Central Asia, South Asia, having crossed the Middle East, to Northeast Asia, North Korea, and down to Southeast Asia, and also, for good measure, Oceania, which is the Pacific Islands. So in some organizations, the blocks are, that bloc is broken up. In the UN Food and Agriculture Organization, Oceania is a separate voting bloc. So those are the geopolitical blocks, but then there are other alignments with them that might be able to leverage voting blocks. So the Organization for Islamic Cooperation has 56 members who comprise all the West Asian majority of Central and South Asian, plus a large number of the members of the African bloc, West and North. So they can leverage often the entire African bloc or the entire Asian bloc for votes. And the core of the Organization for Islamic Cooperation is the Arab League of 22 members out of the 56. So when you think of 56 members without the leveraging, you're looking at almost a third of UN membership just there.
Yeah.
So it's like any representative body, votes count.
Mm.
One of the odd things, though, in UN voting is that we have transposed the idea of one person, one vote to one country, one vote, based on the Westphalian, the European system of diplomatic equality, representation, and equal sovereignty. All votes are equal, whether a country is 1.3 billion Indians or 500,000 Maltese. They have the same single vote, and irrespective of whether they're a representative, democratically elected and accountable government or not. So there's quite a lot of drift from the idea of one person, one vote in the democratic ideal of representative democracy to the UN system, where one nation, one vote actually represents quite a high degree of inequality and is not necessarily representative.
Yeah, and Greg, Israel, just to finish off this topic, but Israel was never accepted as a member of any of those geopolitical groups, I think, until only within the last 10 years.
I think 2002, Israel became a temporary member of the Western Europe and Others group.
Yeah,
I learned that the hard way when I had thought that Israel was already a member when I was a member of an Australian delegation engaged in a negotiation, and I invited the Israeli rep, who didn't belong to any group and had nobody to be meeting and caucusing with. I invited him into the Western Europe and Others group, and everybody kind of froze in shock. That was in the mid-1990s. But by 2002, the Western Europe and Others group had accepted Israel as a temporary member, and then that became a permanent arrangement about a half a dozen years later. Geographically, Israel is a member of the Asian bloc because it's located in West Asia, but it's never been permitted to participate in that bloc and in the Economic Commission for West Asia, which is based in Beirut, only a couple of hundred kilometers away. It's never been permitted to participate.
So it says a lot about Israel's position within the UN. I mean, I think you have over 20 UN member states that do not even accept that Israel exists, let alone have diplomatic relations with it. So it's very isolated, isn't it, within the UN community? I want to move on a little bit to
a point in connection with that, Andrew, which is it's isolated not just in terms of geopolitical blocks, but there also are cultural blocks. You know, there's the Anglophone cooperation. There's obviously Islamic cooperation, but there's no other Jewish country. It's you know, there are countries that have more in common because they're Orthodox, Christian Orthodox, or they're Roman Catholic, and will share certain cultural assumptions and values. So Israel has been termed a nation that dwells alone, in Hebrew, an am boded, going back to biblical passages, but it's still very evident in the United Nations today.
Yeah. Yes, I think Alan Dershowitz started to talk about, you know, Israel as the Jew among in the nations, you know, never quite at home. It's very interesting. I mean, when you think of how Christianity and Islamic religions both developed out of Judaism, didn't they? And so there is a connection with the Jewish world. That's a topic we won't get into now. But thanks for setting that scene about the UN. Now, so what you explained to us is the UN General Assembly resolutions are they're primarily recommendations. They are not instruments of law. The UN General Assembly does not make law. It's not a legislature. It doesn't make binding decisions. Even the Security Council resolutions under Chapter 6 are recommendations only. And yet we see within, for example, the International Court of Justice, and now also the ICC, the International Criminal Court, and many other courts, when they're looking to work out what actually international law says on a specific topic, and Israel and the Israel-Palestine conflict is definitely one of these, they inevitably look to UN resolutions and say, well, the UN said X, Y, or Z about this topic. And they will bring out statements of law or statements of fact. For example, and we'll come back to it, this statement that settlements are illegal. And inevitably, people will say, well, the UN Security Council said in resolution 2334 at the end of 2016, all Israeli settlements are a flagrant violation of international law. Do we have to accept that as a fact?
Well, I think absolutely not. And the reason is that there's an overgeneralization here, because not all resolutions are the same. As I indicated before, this doesn't mean that they're without legal effect. So Chapter 7 Security Council decisions are binding upon members and are subject to enforcement by sanctions, but no resolutions have been explicitly adopted concerning condemnation of Israel under Chapter 7. So then we've got to ask, what other legal effects are there? And to some extent, it's a question of whether one takes a positivist or natural law view of international law. In terms of positive law, that is to say, that can be enforced by a dominant authority, then the recommendations have no power. But do they have other persuasive authority as moral statements, as statements endorsed by the majority of humanity? What is their natural law significance? And for that, again, we have to look at the different resolutions and what they signify. When you think of the Security Council recommendations under Chapter 6, it's the most powerful body within the United Nations, but it's still only 15 members, 5 of whom have vetoes, which are exercised in often arbitrary and capricious ways. Its 15 members are only about 8% of the UN membership, so they don't reflect the unanimous opinion of UN members. And then when we go to the General Assembly, where we have all UN members, often decisions are not adopted unanimously or by consensus, but by votes with high rates of absenteeism. So not all resolutions have the same moral value, the same authoritative value outside of a positivist sense of the law. But they can provide evidence for the development of customary international law, where customary international law is a term that refers to the customs that are considered legally binding that have arisen between countries and which are evident from both their statements of what they believe to be binding and what their actual practice is. So UN resolutions can comprise statements of opinion. And if they are adopted by everybody or extremely widely, then they're evidence of widely held opinion. So even where that opinion explicitly says we consider this to be illegal or we consider X to be the law, that's still just opinio juris. That's not legally binding in itself. In the Libya Texaco case, the arbitrators determined that UN resolutions themselves don't, or rather UN General Assembly resolutions themselves don't form legally binding international laws. The most they can do is provide evidence of opinion of states as to what's legally binding. And it becomes more interesting when we come to the use of those resolutions by judges. Would you like me to go into that?
Yeah, do that, because I think it's judges. There's also a general sense out there, you know, that people talk a lot about the international community, and they say the international community says this, that, or the other. And you get the impression that, if a resolution, even if it's just adopted by a majority, says something, or it says it often enough, it becomes somehow something that we all need to comply with. But I think quite specifically when courts do this, when judicial institutions do it, are they looking in the right way? Do they go deeply enough into the background of resolutions? How does it work?
Well, I guess the central message I would like to convey is that there's not a simple singular answer to any of these questions, because UN resolutions are different between them, and their effects and status are different between them. So where a judicial body looks to UN resolutions, it's going to distinguish between the language of Resolution A and Resolution B. Does Resolution A say that it expresses a legal opinion? Does it say that something is a legal principle, like the principles on friendly relations and cooperation between states, or does it say that a particular activity is illegal? So does it pronounce something that indicates law that a judge can attach to? Secondly, there's the question of whether the judicial bodies wish to or have the authority to critique and to exercise a function of judicial review over the political organs. So for those of us that come from federated states like Australia or Canada or the United States, there's a constitutional instrument which holds the pieces together into a union. And that constitutional instrument has a supreme authority that is interpreted by a judicial body that then is instructing each of the constituent parts and the federal entity as to what the limits of their powers are. So in that sense, where I think lawyers from federal countries have a notion of the law and the court standing above everything else, it's less the case in a unitary political system where the High Council or highest political organ of the state can change the constitution at will. And in those systems, there's an assumption that the judiciary is subject to the political will. So that comprises most of the world's legal systems. And in the United Nations, judges don't take upon themselves a function of judicial review. They don't say that a Security Council resolution was adopted in a procedurally incorrect way and is therefore invalid. And in fact, have declared that they have no such power. In fact, the opposite is true. They take the political authority as persuasive, and it's a tango, a delicate dance, but the general tendency within judicial bodies is to make assumptions that avoid political friction. So that's a second point. The third point I'd make is that judges, when interpreting their own constitutions, the treaty that forms the International Tribunal on the Law of the Sea, or the Statute of the International Court of Justice, or the Rome Statute of the International Criminal Court, are creating a body of interpretation, a body of subsequent practice that interprets their treaty. And it is typically the case, at least since the Permanent Court of International Justice in the League of Nations, which had a more conservative approach, but certainly the International Court of Justice and those under the UN system and in the UN era have a more ambitious, experimental, adventurous willingness to widely interpret their constitutive treaties. And we've seen that in the International Tribunal on the Law of the Sea recently, where it decided it could give advisory opinions, even though that's not provided for in the Law of the Sea treaty, except with a bit of creative interpretation. And we've also seen this in the International Criminal Court, which has been incrementally expanding its jurisdiction by interpreting its own treaty, the Rome Statute, so as to pursue its ultimate objective that there should be no impunity for crimes and that justice should be done. So that mission has led to the use of UN resolutions as interpretive aids, as context for the broadening of their own constitutive documents. So I guess to try and summarize, I've made several points. The last was that UN resolutions are being used in order to expand judicial jurisdiction. The second was that international tribunals tend to avoid friction with the political bodies which in general stand over them. And thirdly, that United Nations resolutions, including General Assembly resolutions, in fact more so than Security Council resolutions because they involve more countries, can provide evidence of opinion as to the development of a customary law.
Okay, thank you, Greg. So as far as Israel and the Israel-Palestine conflict is concerned, there have been two very important decisions made, one in 2004 by the International Court of Justice, an advisory opinion when the General Assembly asked the court to advise on the legal status of the so-called wall or security fence, pardon me, that Israel had was in the process of building after the Second Intifada. And that decision, we won't go into it in detail now, but that advisory opinion, so that tells us immediately it was just an advice and not a binding decision. Was very political in the sense that it was driven by a highly political UN General Assembly resolution, which formulated and brought the issue to the court. And then there was the issue whether the court should even make an opinion on that topic. And we saw in the opinion itself a heavy reliance on UN General Assembly and Security Council resolutions to justify its opinion, for example, that the territories are occupied and that the Palestinians have a right to self-determination in those territories and so forth. That's an example. We won't go into it today. I think we will in another session, but I'd like to dive into the ICC, the International Criminal Court, in February this year.
Andrew, may I just make a comment on the ICJ
sure.
advisory jurisdiction as we move on from it? And that is that just as we have distinctions between UN resolutions, we can make distinctions between different judgments. So if a judgment is one that emerges out of a dispute where both parties had consented to submit themselves to the jurisdiction of the court, then there's a disputed matter and they've agreed to the authority of the decision over them. In the case of an advisory opinion, the initial intention of the advisory jurisdiction of the International Court of Justice was to be able to advise the General Assembly on matters of administration and procedure, but it's being used in a political way in order to achieve political outcomes by the General Assembly. So it provides a really clear example of the politicization of the judicial function, because the actual scope of the judicial opinion is determined by a political process with a political outcome intended. So where a resolution calls for an advisory opinion, then clearly the court is subject to the resolution in delivering the opinion. The opinion determines the scope and mandate of the court. And the court tends to serve its political master, the General Assembly, in its advisory opinions. We saw that dramatically with the Namibia opinions, where there was a dramatic turnaround due to the displeasure with the first opinion that the court delivered. And since then, an appropriately chastened and disciplined International Court of Justice has delivered what's demanded by its political master in providing advisory opinions which are clearly politicized and utilizing its jurisdiction for political purposes. So we can see that certainly in the separation barrier opinion.
Okay, so that's really an internal UN thing, isn't it? Because the ICJ is a part of the UN structure. The ICC, the International Criminal Court, is different because it's set up under a very different statute or treaty, the Statute of Rome. It's not a UN body. And yet in February, the majority of the pretrial chamber, when it was asked whether Palestine is a state for the purposes of the treaty of the Statute of Rome, and the question before it was, because the court only has jurisdiction over crimes committed on the territory of a state party or by a national of a state party, the court was asked whether Palestine, because Israel is not a state party to the ICC, is Palestine a state party, and does it have territory over which the court has jurisdiction? And you were part of a group of experts who made submissions to the court last year. And then after a wait of, I think, about a year, in February, the pretrial chamber came out with its ruling in which it relied heavily on this UN General Assembly resolution, which granted Palestine non-member UN observer state status, opening the door for it to accede to the court. And the court said, we have jurisdiction over this entity called Palestine because the UN has enabled it to become a party to the Statute of Rome. I mean, how does that work? It seems to me a very circular line of reasoning, and is it satisfactory?
Circles are beautiful things. One point in commencing is that the International Criminal Court is a UN body. It's a specialized agency rather than a UN organ. So it operates very much like a specialized agency with an assembly of states parties that determine policy, and then the secretariat underneath it. But it's the body that's composed, its executive is a court. So it's unusual in that specialized agencies aren't generally courts. But the easiest way to think of where the International Criminal Court fits into the pantheon of international bodies is as a UN specialized body, which we'll call a UN specialized agency. And the depository, that is to say, the body that holds the treaty and the instruments of ratification of the treaty, that is the Rome Statute, that constitutes the court. So that determines who has deposited and become a party to the court's statute is the UN Secretary General. And the UN Secretary General receives legal advice from the Office of Legal Affairs. And the legal advisor, Patricia O'Brien, advised after Resolution 67/19 was adopted by the UN General Assembly, giving the state of Palestine, and I say state of Palestine in inverted commas because that is the actual term under which the Palestinian Authority chose to declare its state, just like the United States of America is the name that America adopts, or the Commonwealth of Australia. It's the state of Palestine as chosen by Palestine, just to emphasize the point for the purposes of international bodies. And so the Office of Legal Advisor said that pursuant to this resolution, recognizing Palestine as a state and giving it observer status, even though as a non-member, we have to consider it as a state, and we have to adjust its status in dealing with UN organs similarly. So the only other country currently with a similar status is the Holy See, the Vatican. which is regarded as a state and yet is not a UN member. The result is that the Vatican has observer status and it engages in diplomatic relations and has a range of bilateral treaties and multilateral treaties that it participates in. And so Palestine is being treated in the same way pursuant to the UN General Assembly resolution. But there is a difference between the two cases in that the Vatican has although it's only a square kilometer in Rome, it has defined borders, it has a defined population and government. And those are criteria under the Montevideo Convention that was adopted in the second quarter of the 20th century for recognizing the status of states that have decolonized in Latin America. And the fourth component is that it's recognized as a state by other states. So if we compare that to Taiwan, Taiwan has a defined population, territory, government, but most countries now are not recognizing it as a state. And therefore it's not treated as a state, it's not a UN member, it has no status within UN bodies. On the other hand, Palestine, population is not clear. It's not just by the definitions of the UN Works and Relief Agency for Palestinians in the Near East. It is a much broader diaspora that comprises the population. The borders are unclear, and exactly where the government is active is unclear as well, because the Palestinian Authority doesn't govern in Gaza. But nevertheless, there is recognition in the UN General Assembly by a majority of states pursuant to that resolution. And then we go into the resolution itself and look at its terms in detail, and we find that the resolution is quite ambiguous. It's in many ways internally inconsistent, and explanations of vote that were given by countries that voted in favor said that they saw this as an aspirational statement towards a two-state solution where Palestine would become a state. And in fact, the resolution in its own next paragraph, after changing the status of the of Palestine to a non-member observer state, goes on to say that the Palestine Liberation Organization continues to be the representative of the Palestinian people without any prejudice to its status. So it seems to have it both ways. It's quite internally inconsistent. Maybe the final point to make in that connection is it's a non-member because after that resolution was adopted, a proposal was brought to the Security Council for Palestine to become a full member, and that proposal was rejected. And the Security Council is the body that has the final say on who becomes a UN member.
Okay. So the bottom line is the court said the very fact that Palestine, on the back of this UN resolution, submitted its papers of accession to the Statute of Rome, to the ICC, and you know, in real terms became an ICC state parties, and nobody objected to it, or at least not formally.
Canada did. They lodged an instrument objecting,
right.
And about 3 other countries made objections informally. Australia sent a letter to the UN Secretary General, although not as a formal instrument of objection. And I think Germany and Czech Republic made public statements, as in by their ministers of foreign affairs, saying that they rejected this, but they didn't take any formal action.
No, so, well, we'll come back to that, because the fact they didn't take any formal action meant that Palestine became a full state party. And that's one of the reasons the court says that the court is now presented with the fact of Palestine having become a state party. And the court says, well, it's not our job to look at whether it's in fact a state or not under international law. We just have to accept this train of events, which all came out of a General Assembly resolution, which in itself, as you say, didn't quite say what people think it said. And so now we have an investigation on the basis of a court decision saying it has jurisdiction. Can you just briefly tell us a little bit about Judge Kovac, the Hungarian, because he wrote a long, very lengthy, very reasoned dissenting opinion criticizing the majority's view in no uncertain terms, saying that the legal reasoning is he calls it acrobatics, I think. He says the court had no basis for reaching this decision. What was his concern? What was his main criticism?
Well, the majority of his 130-page dissent, which excoriated the majority judgment, which was 60 pages. So that majority judgment, the first half of it recounted the history of the case, and then there was 30 pages of opinion, which were quite weakly argued, but then with a partially dissenting opinion by one of those two judges, Marc Perrin de Brichambault, the French judge, concerning a question of jurisdiction, to give the confirmation of jurisdiction. So we have those two judges, so Sophie Adelaide Alpini-Ginsu and de Brichambault in the majority, and Peter Kovac in the minority. So Kovac is the more senior, he's the president of that panel, pre-trial chamber one, and a Hungarian academic and judge who's an expert in international law, and his 130-page judgment spent a great deal of time looking at the UN resolutions that were actually cited by the prosecutor and endorsed by the pre-trial chamber majority, noting their inconsistency and inability to actually deliver anything that was legally binding. So acrobatics, because something that was a recommendation and unclear was ultimately given legally binding effect, because Patricia O'Brien, the legal advisor, had told the Secretary General, who had accepted the ratification, which meant that the prosecutor and the majority of the pre-trial chamber said, look, this is binding law. And President of the pre-trial chamber, Kovac, said, the Office of Legal Affairs opinion doesn't create binding law, and there's no authority to assert that UN recommendations made by the General Assembly have legally binding effects on other UN members that have been created in this way by taking them and the majority judgment didn't critique or analyze resolution 67/19 at all, just said this is what it does without any analysis. And so the president of the chamber argued that not only does the resolution not say what the majority says it does, but it has no legal authority to have these legally binding effects. There's a distinction that can be drawn between whether it made Palestine a state simply for the purposes of the International Criminal Court, which was the principal argument of the prosecutor, and was the basis on which the majority ruled in favor of the prosecutor's ability to prosecute, and whether Palestine is a state under customary international law and the Montevideo Convention principles, which the pre-trial chamber didn't decide upon, and which Judge Kovac said there's no meeting of the criteria here, obviously, on that question.
Okay. Okay, Greg. We're going to move, I think, into the Q&A here. We had a number of other issues that we could talk about to explore further, but we will do this more in subsequent webinars. one of the questions has been asked, have there been other minority opinions, such as this one by Kovac, in the ICC with a similar length or breadth of dissent? Or is this unusual to have? Because it's a very extensive dissent and it's a very strong one. And as you said, it's by the president of this chamber. How exceptional is this?
This is exceptional to the best of my knowledge, Andrew. And the judge took this upon himself, perhaps for several reasons. One is to protect the International Criminal Court, because the politicization of the court is the ringing of the bell of its death knell. And so it's very dangerous for the court for it to be politicized. It's one thing for an advisory opinion to be given, which is clearly politicized, but has really only rhetorical and political uses. Once we're talking about a criminal justice body, which has the power to conduct arrests, to issue secret warrants, and to seize people when they travel internationally and put them behind bars, then it's a responsibility that has to be taken very seriously and not politicized. So I think he was trying to protect the court. One also has to look to his authority as compared to the other two judges. Alpini Gansu was a human rights activist and lawyer in Benin, and when it comes to ranking the appointments of judges, the selection panel considered her to be eligible because competent, but at the lowest level of competence. And de Brichambeau was primarily a diplomat lawyer within the French diplomatic service. So neither of them carried the same authority as Peter Kovac, and seemed to be willing to serve a political function on the ICC that he obviously felt very strongly about.
So where does that leave this? Because it's a decision now made by the pretrial chamber. We have Kovac's dissent, but he was in the minority. It was a dissent. What can be done at this point by Israel or by any other state party on this issue of jurisdiction? Can the question of jurisdiction be raised again? Can the prosecutor decide that we have a new prosecutor coming in June, Karim Khan, a British QC, who will replace Bensouda? He will be a very different person from the current prosecutor. Can he decide not to investigate things because he agrees with Kovac? What are the options?
He certainly can, but it's very unlikely in that the current prosecutor, Fatou Bensouda, announced her intention to proceed with the investigation, which the chamber noted had already commenced informally prior to their providing their judgment, as she had authority to investigate anyway. But then when she announced she was formally proceeding with an investigation, there can be no doubt that she consulted first with Karim Khan, and that this was a way to protect him from pressure later on to not commence the investigation. So now that makes it a more uphill task in order to pressure him to stop the investigation. The independent expert review on the International Criminal Court that reported in September last year found that there was a great deal of opacity and dissatisfaction with prosecutorial decisions or exercises of discretion on which cases to investigate and take forward. And this one seems to be clearly a very political one. So I think primarily the tools that can be brought to combat it is, first of all, to identify clearer criteria, more responsible criteria for the selection of cases for prosecution. Further, the matter can be raised in the Assembly of State Parties for discussion or as a dispute under Article 119 of the statute. The circle, though, comes back to haunt us there because the Assembly of State Parties decides matters by a majority, and a majority in a political body will vote with the Organisation for Islamic Cooperation in the Assembly of State Parties, so that any dispute raised there will be decided against the minority dissent. It's noteworthy that prior President Donald Trump of the USA imposed sanctions in June last year on prosecutor and deputy prosecutor in relation to their examination of US forces for war crimes in Afghanistan. Those sanctions were lifted by the Biden administration in February, but there's a possibility of sanctions in future under United States congressional legislation in the act that was adopted under the Bush administration to curb the power of the International Criminal Court. And furthermore, the United States has a series of bilateral agreements under Article 98 of the Rome Statute. They take precedence over other obligations under the statute. So those Article 98 agreements with the US can be used by the US to stop other countries from cooperating. I mean, there are a range of different tactics that can be used. I think that a great deal of the resources that are available to the court in this investigation are being provided by legal advocacy NGOs funded by European governments, some of which have provided aid specifically for the promotion of prosecutions of Israelis. There can be actions taken against those aid monies. There can be actions taken against those NGOs to restrict their activities, and more diplomatic coordination with states that are not hostile to Israel could form hopefully a more proactive bloc rather than those that are simply willing to look the other way and say, this is not my problem.
What about Israel,
Greg? One day
Greg?
it'll become their problem.
Right. What about Israel, Greg? What can Israel do at this point? Israel not being a member of the ICC, I think Israel has announced it will not cooperate with the court. Is there anything else Israel can do?
Israel can suppress the activities of organizations under its jurisdiction, or that transit funds through its jurisdiction, and work against it. So in the same way that it passed a law to suppress boycott, divestment and sanctions activity within its jurisdiction against it, it could include in that as boycott, divestment and sanctions activities that are supporting the ICC prosecution. I don't think it would be of any use for Israel to join and cooperate with the court, because this is a completely uneven playing field where the very terms of the crimes that the court has jurisdiction over were crafted in order to meet the demands of the Organisation for Islamic Cooperation to facilitate prosecution of Israelis for building and living in the West Bank, Judea and Samaria, where those crimes weren't otherwise crimes under the 1949 Fourth Geneva Convention. So it's been designed for the prosecution of Israel.
Greg, the Security Council said in Resolution 2334 that Israeli presence in the West Bank is a violation of international law. At least they say settlements are a violation of international law. Settlements are nothing more or less than Israelis living in those territories. Now, the court, the prosecutor, has said one of the crimes that she's investigating is settlements, because, as you say, she regards them as a crime under the Statute of Rome, because they amount to transporting or deporting Israelis into the occupied territory. Will the prosecutor regard himself as being bound by Resolution 2334, a Security Council resolution, which many people regard as being binding?
So 2334 was adopted under Chapter 6 as a recommendation, not under Chapter 7. So it's a recommendation, but it states a finding of law. So the statement made by 14 members of the Security Council provides evidence of legal opinion, opinio juris for a legal principle. It's an interpretation of the 1949 Fourth Geneva Convention and of the Rome Statute. But really this goes back to where we started today, where a UN resolution, which has the status of a recommendation, which within its own terms expresses itself as making a legally binding declaration or legal finding, is not in itself binding. It's merely evidence that can be used to build a case that there's opinion out there that there is international custom that makes this illegal.
Right.
So will the prosecutor, Karim Khan, argue that Security Council Resolution 2334 is not binding, not relevant, merely a recommendation? Certainly he won't. That would undermine his scope of authority and power, and a guiding principle is one doesn't chop oneself off at the knees. So there's within international judicial bodies, and the prosecutor is a part of the court, it operates along the civil criminal law system model where the prosecutor is an officer of the court. The prosecutor actually has a staff just in The Hague of between about 450 people, and will draw authority from that resolution, will argue that it is legally binding. But it remains to the judges, however austere or politically compliant they might be, will depend upon them to interrogate the assertion that 2334 provides a legally binding finding. Okay,
thanks for that. We're going to deal with just a couple of other questions before we draw this webinar to a close. Avi Solomon has asked a couple of questions about the decision of the court. First of all, how can the ICC claim jurisdiction outside the West Bank? The PA doesn't even have authority, for example, in Gaza. This assumes that the PA is understood as the single authority replacing the PLO. So just on that, I mean, we have three different kinds of creatures out there. You have the state of Palestine, you have the PLO, and you have the Palestinian Authority, and none of them have control over the Gaza Strip or the Golan Heights, for that matter. How can the court reach a decision that it has jurisdiction over those territories?
Well, I think the Golan Heights are out of the equation because they were, for 21 years at least, they were Syrian territory. The United Nations information system on Palestine includes data on the Golan Heights, but actually they were never regarded as a part of Palestine under the partition resolution of 1947. So we'll leave the Golan Heights out, and essentially then after 1967, pursuant to resolution 242 adopted by the UN Security Council under Chapter 6, calling for peace negotiations and secure borders for Israel and a return of territories that were occupied during that war, resolutions that have subsequently been adopted by the General Assembly have referred to all the territories that were occupied in 1967 that were designated to be part of the state of Palestine. So over 90% of the territories occupied by Israel have been surrendered by Israel. Most of it was the Sinai Desert that went to Egypt under the peace treaty. Then in 2005, Israel left the Gaza Strip. So what really remains is East Jerusalem and the West Bank, Judea and Samaria. And that's the language then that's been adopted in subsequent UN resolutions, including that which recognized the state of Palestine as a non-member observer state of the United Nations. And so the majority in the pretrial chamber judgment simply took that formulation of the 1967 territories in total. Interestingly, under Resolution 181 of the General Assembly for the partition, Jerusalem was never to be part of Palestine, nor for sure the capital of Palestine. It was to be an international basin, under United Nations administration.
Yeah. So one final question. There are a number of other questions people are asking, and I'm afraid we don't have time for all of them. But one thing that does arise is all of this sort of reliance on UN resolutions. By definition, these are resolutions which have only been passed since 1945. So there's a whole history of these territories before 1945. As we all know, the state of Israel was born out of the mandate for Palestine, which was born out of the decisions after the First World War and the San Remo resolution, which got the ball rolling on the basis of the Balfour Declaration. Now, all of that history, and I think the International Court of Justice, even in the Wall decision, said, we don't make an opinion about the status of these territories. They were very careful, I think, not to make a definitive statement about the territories. Yet now we see an International Criminal Court and other courts saying, well, the UN says this territory belongs to the Palestinians, therefore we accept that that's the case. So all of these historical and legal arguments based on legal events prior to 1967 simply get swept aside. Can you comment on that? We have to keep it short. I'm afraid it's going to be the subject of, I think, more discussions in our webinars. But how do we see that?
Well, I suppose we live in an age of quick messaging, 180 text characters, and we forget the longer and more detailed histories and authorities of the past. So the League of Nations mandate was a legally binding mandate to create a Jewish homeland in the area that was the British mandate of Palestine. And that included, of course, Jerusalem and the area of Judea and Samaria today. So that the influence of that mandate as a legal legacy is simply glossed over in our quick messaging concerning a UN resolution on this and that, which is adopted in language which is inconsistent with prior resolutions, internally inconsistent and impossible of fulfillment, but really who cares? It's just a UN resolution.
Thanks. Well, there's so much more to be said on all of this. Thank everybody for your participation. Thank you, Professor Gregory Rose, down in Wollongong, Australia. We haven't had time to deal with the many other questions that have come up, but we take a note of them and we will be dealing as much as possible with these issues in coming webinars. So please keep connected with us. We will be doing more of these webinars in the coming weeks. as we explore and go deeper into these very important issues. Again, my thanks to Professor Gregory Rose, and
I'd like to thank you, Andrew, and thinc for having me on tonight, and to congratulate you on the excellent work that you do. And I wish you strength and success in your future seminars.
Thanks so much, Greg, and we'll look forward to doing more together. Thank you again, and we look forward to seeing you all same place, same time, next time at the next conversation. Thank you. Back to you, Ana Rosa.
Yes, thank you also from my part. Just to let you know, the recording of today's conversation will soon be made available on our website. And also would like to draw your attention to the next episode of our conversations series that is scheduled for May 27th. And we also have a very interesting guest, Dr. Daphne Richmond-Barak from the IDC Interdisciplinary Center in Herzliya in Israel. And she will speak with us about the Abraham Accords and international law. So we look forward to meeting with you soon again. And bye for now. Have a great day or great evening, wherever you may be.